Hi, everyone, and thank you for joining us today. My name is Krista Chavez, and I'm the Senior Communications Manager from NetChoice, and this is my colleague, Heather Greenfield from CCIA. And I'd like to give you a rundown on how this is going to work really quickly before we jump in. So Matt and Chris will each give remarks and reactions to oral arguments, and then we'll have some time afterwards for Q&A. When it is time for Q&A, I just ask that you please raise your hand, and when Heather Greenfield from CCIA calls on you, please clearly state your name and outlet. Please repeat that information if we call on you twice. When Q&A is finished, Heather and I will be around afterwards to give y'all our business cards and chat if you'd like to after. NetChoice is a trade association dedicated to protecting free enterprise and free expression online. And we are here with the Computer and Communications Industry Association, which has promoted open markets, open systems, and open networks for over 50 years. In 2021, NetChoice and CCIA joined forces to sue the states of Florida and Texas over two laws they passed that infringed on the First Amendment rights of private online businesses to determine what content they host on their services. 3 years later, we're here in front of the U.S. Supreme Court, and we're excited to discuss today's arguments with you. For our speakers, we have Matt Shears, the president and CEO of CCIA. Shears is an expert in internet law, intellectual property, competition, and international trade. And our second speaker, Chris Marchese, is the director of the NetChoice Litigation Center. Marchese has legal expertise in First Amendment litigation, administrative law, and antitrust law. Please welcome our speakers.
Good afternoon. Today, the court heard argument on one of the most significant questions for the Internet and the First Amendment, and that is whether the state can compel a private website to disseminate content on a private service that site disagrees with. We told the court today that no business, whether a newspaper, a bookstore, a parade, or a website, should be compelled to disseminate messages that it thinks are unsuitable for its audience. The stakes here are very high. Neither Florida nor Texas could escape the fact that these viewpoint dissemination laws would mandate the dissemination of misinformation and disinformation, of terrorist sympathizers, of hate speech, and suicide promotion. And that is why these statutes put everyday Americans at risk. The bench pressed both Florida and Texas on their dubious theory that websites can be magically designated as common carriers. And Florida and Texas had to concede that the editorial discretion that these websites engage in is First Amendment protected activity. The court has now heard that the state has no business protecting individual viewpoints or picking winners and losers in the marketplace of ideas. If the First Amendment means anything, it must mean that the state cannot compel a private actor to disseminate a viewpoint that it disagrees with. We are confident that we are on the winning side of centuries of First Amendment jurisprudence, and based on today's argument, I look forward to a ruling in our favor that will pave the way for a freer and a safer internet for all Americans. I'll give you my colleagues from NetChoice.
Good afternoon, everyone, and thank you for being here today. My name is Chris Marchese, and I'm Director of Litigation at NetChoice. As my colleague Krista said, for over 2 decades, NetChoice has fought to protect free speech and free enterprise online. Just today, the United States Supreme Court heard oral arguments in our landmark lawsuits against the states of Florida and Texas for trying to control online speech, dictating what content can be published online and by whom, and dictating what can be seen or read online and by whom. If there's one thing that today's oral arguments made clear, it is that the First Amendment hangs in the balance. The states of Florida and Texas are attempting to control the greatest vehicle for free expression in human history. Our cases serve as an important reminder of American exceptionalism. Our First Amendment protects not only free speech, free expression, and free thought, it does so unapologetically, because our Constitution draws a very clear line between the government on the one hand and all of the rest of us on the other. The government cannot violate the First Amendment, and it especially cannot do so in the name of preserving free speech. That is Orwellian. Now, ladies and gentlemen, you heard a lot of talk in the oral arguments today about Section 230, the pre-enforcement nature of our lawsuits, but let one thing be clear. This is about who gets to decide how to exercise your First Amendment rights. Can the government tell you how to exercise your God-given rights? Or is the Constitution meant to protect us against the government? Now, just as the government cannot force Benjamin Franklin to run its preferred messages in his newspapers, it cannot force Florida and Texas to disseminate their preferred messages online. And just as the government cannot achieve indirectly what it is prohibited from doing directly, the states of Florida and Texas cannot use so-called disclosure or transparency laws to achieve what the First Amendment prohibits outright. Ladies and gentlemen, the consequences of today's cases are unparalleled. Liberty stands in the balance because at the end of the day, the internet is the greatest marketplace for free expression in human history. It has connected like-minded individuals, allowed communities to flourish, and still exposed us to different points of view. It has also leveled the playing field between rich and poor, rural and urban, politically favored and politically disfavored, by putting all of the world's accumulated knowledge and wisdom at our fingertips, and mostly for free. The internet has been life-saving for many, and it must remain free from government encroachment for all. In closing, let us rally around a simple yet profound truth. Free speech and the First Amendment are worth fighting for. Whether it's on or offline, free speech must rule the day, and we are confident the Supreme Court will agree. Thank you.
So if you have questions, if you can state your name and the news outlet you're with.
First Amendment activity.
And while they're thinking of what they want to ask, we heard a lot of talk inside about what dictates editorial discretion. Could each of you talk a little bit more about that argument?
Absolutely. So editorial discretion is just a fancy word for First Amendment activity. You know, if you're a publisher of a newspaper, a publisher of a magazine, an art gallery owner, at the end of the day, you are making decisions about what content you want to keep in and what content to exclude. And so the states of Florida and Texas have this novel idea that editorial discretion is only something that newspapers have. Again, that would be news to curators of art, museum curators, and of course, social media, because ultimately these laws were passed because the states of Florida and Texas disagreed with the way that private websites were exercising their First Amendment rights. We heard time and again from lawmakers and governors saying that social media reflects a liberal Silicon Valley outlook and that they are suppressing speech. And yet today we actually heard at oral arguments that conservatives are killing it on social media, right? Ben Shapiro is doing very well. And yet none of that really matters because ultimately this isn't about preserving free speech. These laws were about punishing the First Amendment activities of private websites that the states disagreed with.
If I could add to that, I think Chris covered the question very ably. I would note that for those of you who listened to today's oral argument, you may have heard both states at various points, and Texas in particular, desperately attempting to reframe the editorial choices of website as conduct. And by labeling it conduct, that somehow falls outside the First Amendment. Now, there can be no question that websites are making choices every day to benefit their users, to protect their users from dangerous activities online, whether that's foreign disinformation, self-harm, trolls, predators. Clearly, the efforts to protect individuals from that kind of conduct must be construed as speech, or these websites' efforts would have no protection for their users.
Just to add on to Matt's point, Justice Kavanaugh had a question for the state of Texas about could private websites remove pro-Al-Qaeda speech? And the state, after trying to avoid the question, eventually had to answer honestly, which is, if you allow anti-Al-Qaeda speech, you must also allow pro-Al-Qaeda speech. That is how ridiculous these laws are. This is not about protecting the marketplace of ideas. It is about destroying it.
Any questions? Yeah.
Hi, I'm Hajra. I'm with Tech Policy Press. I'm just curious if any of the justices' questions caught you guys by surprise, or if there were any moments of general wonder.
I mean, I think with 9 justices who all have their unique jurisprudence, we sort of expected that we were going to be asked a gambit of questions, but there was nothing that came up at today's oral arguments that astounded us. In fact, I think what you saw from the justices were thoughtful questions, hypotheticals, about trying to really get to the bottom of what is at issue in these cases.
Yeah, I think after months of preparation, it's difficult to, not to anticipated the vast majority of questions that came forward today. So our counsel was more than prepared to answer all of them. If I had to pick one, the question was, how much would YouTube weigh? I think was probably a question that wasn't anticipated. But the answer to that question is the unimaginable volume of all that information simply underscores the importance that websites have editorial discretion to decide what is and is not appropriate for their particular communities.
Anyone else?
Maddie Hughes
Yeah.
with MLEX.
Yeah.
I'm wondering about the Section 230 questions that you guys all received earlier today, and how you hope that the justices decide this. Should it be more decided on the First Amendment, or what should they say about Section 230, if anything?
Okay, you go first this time.
So this case has been presented to the court as a First Amendment question. There is the secondary question of whether or not Section 230, the federal statute that provides that websites have the ability to remove problematic content without assuming liability for everything on the internet. There is a question of whether or not that statute should decide this case first. Now, the fact of the matter is that both Florida and Texas allude to this statute so as to avoid the obvious First Amendment challenge of their underlying legislation. I think there's no question from what I heard from the courts today that this First Amendment proposition cannot be escaped. And once that matter is decided, the Section 230 issue really goes away, because if the states cannot engage in this viewpoint equality practice, the other issues become insignificant.
I think at the end of the day, our cases are primarily about the First Amendment, and Section 230 is a distraction. What we saw in oral arguments were justices asking, thoughtful questions, but ultimately they have a very simple answer. Section 230 says, if you are a publisher, an interactive computer service publisher, you will not be treated for liability purposes as a publisher of certain content. That doesn't somehow strip you of your First Amendment rights. It doesn't transform you into a common carrier. It is simply Congress saying, we would like you to exercise your First Amendment rights more, and to help you do that, we're going to make you immune to certain forms of liability. For what it's worth, Congress has done this with several industries. For example, gun manufacturers are immune from certain forms of lawsuits because Congress feared that lawful arms would not be sold, and as a result, Americans would not be able to exercise their Second Amendment rights. So gun manufacturers are not transformed into anything else just because they are immune to certain lawsuits. Here, we're talking about the First Amendment, and it's even more significant because we're talking about billions of pieces of content.
And Madeline, I think the fact that the 230 came up during our First Amendment case just shows that there are just as many people who think internet companies are doing too little to take down content as there are companies doing too much to take down content. Anyone else? Any final thoughts?
Thank you all for coming. Appreciate it. And Heather and I will be sticking around afterwards to take your cards and answer any questions that you'd like. Thank you.
Have a great day, everyone.